Imagine a case so controversial, it could shake the very foundation of marriage laws across America. That's exactly what's happening right now, as the Supreme Court has been asked to hear a challenge that could not only upend the 2015 ruling that legalized same-sex marriage nationwide, but also potentially absolve a former Kentucky county clerk who was jailed for refusing to issue marriage licenses to same-sex couples. This is more than just a legal battle. It's a moment that could change the conversation on rights, religion, and the reach of the Constitution. And it's playing out at the highest court in the land. At the center of this storm is Kim Davis, the former Rowan County clerk in Kentucky. Back in 2015, shortly after the landmark Supreme Court ruling in Obergefell versus Hodges recognized same-sex marriage as a constitutional right, Davis refused to issue licenses to same-sex couples, citing her religious beliefs. That refusal not only made national headlines, it led to her being briefly jailed for contempt of court, a first in U.S. history for someone holding her specific position. Now, years later, Davis is fighting back, asking the Supreme Court to take her case. In her latest appeal, Davis argues that her actions were protected by the First Amendment's guarantee of free exercise of religion. Backed by the religious advocacy group Counsel, she says she was punished for staying true to her beliefs about what marriage should mean. Her legal team claims the Obergefell ruling itself was wrongly decided, calling it a legal fiction that set off a chain of events stripping her of government immunity and leaving her personally liable for large financial judgments. This isn't just about principle for Davis, it's also about money. Lower federal courts have already ruled against her, requiring her to pay $100,000 in damages to one of the couples she denied, plus more than $260,000 in attorney's fees. The couple, David Ermold and David Moore, maintain that the Supreme Court shouldn't even take the case, pointing out that no judge on the U.S. Court of Appeals showed interest in reconsidering her claims. Their attorney, William Powell, said he's confident the High Court will reject her appeal. But Davis's petition to the Supreme Court goes beyond her personal situation. It takes direct aim at the legal framework that led to the legalization of same-sex marriage. Specifically, it challenges something known as substantive due process, a principle that allows courts to recognize certain fundamental rights, even if they're not explicitly written into the Constitution. This concept has been used to protect rights to privacy, interracial marriage, and same-sex marriage, and until recently, abortion rights before Roe v. Wade was overturned in 2022. What's striking is that Davis's appeal quotes heavily from two sitting Supreme Court justices, Clarence Thomas and Chief Justice John Roberts, who dissented in the original Obergefell decision. By leaning on their past criticisms, Davis's team is hoping to convince the court that now, with a more conservative majority, the time might be right to revisit and possibly reverse that 2015 precedent. The implications of such a move would be enormous, not just for same-sex couples, but for the stability of other rights based on substantive due process. It's important to remember, though, that public opinion in the United States has shifted significantly since 2015. Surveys show that more than 2/3 of Americans now support same-sex marriage. That makes any potential reversal politically sensitive, even if the court decides to take the case purely on legal grounds. Still, the petition arrives at a time when certain conservative advocacy groups are pushing to roll back the Obergefell protections, and at least 9 states have introduced legislation aiming to block new same-sex marriage licenses or urging the Supreme Court to overturn the ruling. Religious organizations are also weighing in. In June, the Southern Baptist Convention, the largest Protestant denomination in the country, made overturning the Obergefell decision one of its top priorities. Their resolution doesn't carry legal force, but it signals a strong and organized push from influential groups to challenge the 2015 decision head-on. For supporters of marriage equality, that's raising alarms about a coordinated effort to turn back the clock on hard-won rights. If the Supreme Court does agree to hear Davis's case and then decides to overturn Obergefell, marriage laws would once again be set at the state level. That means each state could decide whether to issue marriage licenses to same-sex couples. However, under the Federal Respect for Marriage Act passed in 2022, both states and the federal government would still be required to recognize marriages performed in states where same-sex marriage remains legal. In practice, that could lead to a patchwork system where rights depend heavily on geography. For now, the big question is whether the Supreme Court will even take the case. The court receives thousands of petitions each year, but agrees to hear only a small fraction. The decision on whether to grant review could signal how much appetite there really is among the justices to revisit one of the most significant civil rights rulings of the 21st century. Even the act of accepting the case would ignite a nationwide debate and put same-sex marriage back into the center of American political discourse. Kim Davis's story is a complex one. To her supporters, she's a symbol of standing firm on personal beliefs in the face of legal pressure. To her critics, she's an example of an elected official refusing to uphold the law and violating the rights of her constituents. The truth, as always, is wrapped in legal arguments, constitutional interpretation, and deeply personal convictions. The Supreme Court, if it takes the case, will have to navigate all of that while knowing that its decision could define a generation. Until the court makes its move, all eyes will be on Washington. Will the justices let the lower court ruling stand, leaving Davis responsible for the damages and keeping Obergefell untouched? Or will they step in, potentially reopening a battle many thought was settled nearly a decade ago? One thing is certain: whatever the outcome, this case will be remembered as a pivotal moment in the ongoing conversation about the balance between individual rights, religious freedom, and the laws that govern us all. Beyond the headlines, this case also raises big questions about the role of public officials in a diverse society. When someone is elected to serve all citizens, can they refuse certain duties if those duties conflict with their personal beliefs? For decades, courts have wrestled with how to balance religious freedom with the obligation to uphold the law. Davis's case could become the next major test of where that line is drawn, and whether it shifts depending on the political or cultural climate of the time. Another layer to this story is the financial and emotional toll it has taken on everyone involved. For the couples who sued, the legal fight was about more than just a piece of paper. It was about being treated equally under the law in their own community. For Davis, the battle has spanned nearly a decade, bringing both national attention and intense criticism. In a way, her case has become less about one county in Kentucky and more about a nationwide reckoning with how we define rights in America. It's also worth noting how dramatically the Supreme Court itself has changed since 2015. Back then, the Obergefell decision was a narrow 5-4 ruling, with a very different ideological makeup on the bench. Today,